Miller, if you have a
Your
page,
Honor.
you're going to evict.
The plaintiff claims that the notice was posted on the inside of our front door on March 6th, but unfortunately that never actually happened.
South as an agent for Fairfield South Lamar versus Morgan Miller, Lauren Reguson.
In today's case, a landlord is trying to evict a tenant for over $6,500 in unpaid rent. The tenant's confident she's found a legal loophole to get the whole thing dismissed. But let's see if she's found a way out or just digging herself deeper.
Good afternoon. Thank
Do
you.
I have someone for Lauren Reguson?
I'm appearing on behalf of both of us.
Okay. Anyone else as an occupant?
Nope, that's just us.
All right then. Ms. Carcos, why is this eviction sought?
This is failure to pay rent. Rent is $2,205 a month. They owe $1,418.58 for January, the full amount for February, March, and the prorate amount of $735 for April, for a total of $6,563.58 in back rent through today. A 3-day notice to vacate was given on March 6th. And it was posted on the inside of the door. It is not a CARES Act property and there's no government subsidies. And we're seeking back rent, court cost, and possession.
All right. Thank you. All right. Ms. Miller, so Ms. Carco says that she's an agent. She works for a company called Nationwide. So if you've never seen or heard of Nationwide, that's why.
Understood.
What you told me is that this is a case solely about non-payment. So it's a financial situation and no other types of allegations. She said that the base rent each month, the flat monthly rent, is $2,205. Is that amount correct?
Yes, it is.
Okay. And she said that there was a balance owed in January and that rent was not paid at all for March, February, or now April. Is that correct?
Your Honor, I had actually worked out a payment plan in writing with my building, and I actually also submitted a motion to dismiss, which I believe is actually now on the docket, based on procedural issues with the notice to vacate required under Texas Property Code 24.005 was never lawfully served. The plaintiff claims that the notice was posted on the inside of our front door on March 6th, but unfortunately that never actually happened. Both my partner, Lauren Reguson, and I worked from home, and we were inside all day. No one had knocked, no one entered, and nothing was taped on the in or outside of the door. But the truth is, even putting that aside, Your Honor, the timeline doesn't make sense based on the plaintiff's own communications. Prior to this case, as I mentioned, we'd entered into a formal payment plan. The first installment I paid, which was $3,000, and the second installment of $1,500 was due on March 7th, which was a Friday.
Okay.
Now, on March 7th...
If you can defeat the notice to vacate, I don't even need to hear the rest of it. So let's stop right there.
Understood.
Ms. Carcos, do you have a witness who's going to testify for the delivery of the inside of the front door?
I believe Jordan Ambrose is on, and he is the one that he's the one that posted the notice to vacate. Mr. Ambrose, can you unmute?
Hi, yes, I am here.
Yes, good afternoon. Sorry. Please tell me your name.
My name is Jordan Ambrose.
And what is your relationship with this situation, with this matter?
I am the assistant manager at 1515 Apartments.
All right. Do you have any personal knowledge about the delivery of the notice to vacate to the defendant's apartment?
I do, yes.
Are you the person who delivered it?
Yes, ma'am.
When was that?
That was on March 6th.
What time of day was it?
I would say around 12 p.m., 12:30.
Why do you know that?
I did not, I posted it on the inside of the door. I did not take a picture on my cell phone of the delivery. So I don't have any proof, but I submitted and attached to Morgan's file in the system.
My question was, how do you know what time it was? Like, you're there at your job. Did you make a note on it? Was someone with you? Did you go back and you're like, oh, I know it had to be about noon because I had lunch? Are you just thinking it might have been middle of the day? Do you know, or are you just guessing? It's very important that you only tell me things you know.
Yes, I had lunch around 12:30. So I posted the notice to vacate 12.
Miss Miller says she was home and you didn't talk to her. How is that possible?
I had knocked on the door. I was the only one. No one came with me to deliver the notice to vacate. I knocked on the door. I had a key to the apartment. I opened the door and I stuck the notice to vacate and taped it on the door.
Miss Miller, would you like to ask Miss Ambo questions? As defendant, you have the right to cross-examine her.
Yes, please. Hey, Jordan, Miss Embo. If on Thursday, March 6th, you entered the apartment at around but somewhere 12 or 12:30 to tape the notice to vacate on the inside of my door. I mean, our apartment is 700 square feet. How many times did you knock before entering? We were home all day, so I'm just trying to see how we could have possibly missed that.
I had knocked at least twice.
Okay, and then just out of curiosity, the following day on March 7th, you left me a voicemail, which I have here, and Your Honor, if you so pleases the court, I'm happy to play it for you. And I have a transcript that says, "Hi, Morgan, this is Jordan here at 1515. I was just giving you a call in regards to that $1,500 check that you're supposed to bring today. We do close at 6, so if you're able to stop by the office before then, I would greatly appreciate it. If you can give me a call, please give me a call back at the number. Thank you so much. Bye-bye." I have that in a voicemail, and then I submitted to the court with my motion to dismiss an email from March 11th where you had reached out to me stating that given that I had not been able to come up with the funds for the second payment in the agreed payment plan, that you would have to file eviction with the court the following day, March 12th. At this point, given that you have called and emailed me, it seemed as though your understanding of a payment arrangement was still in place until the 11th. Am I incorrect in that?
So the policy and procedure is to provide a 3-day notice to vacate. So when I posted on the inside of your door, I know that we did have a payment plan agreement that was approved by the regional manager. In failure to do so, you did not provide the $1,500 payment and certified funds. So there was nothing for us to do besides file eviction.
We're good. Miss Ambo, Miss Miller, Miss Carcos, I just read y'all's documents. We're good. Here's what we got. It's going to be a judgment for the defendant, and here's why, because of the timing of the situation. So the documents prove it very clearly. You're like, Miss Miller, if you haven't paid your rent, they're going to evict you, right? This is a technical win for you. In no way does it mean you haven't paid rent correctly, right?
Of course, Your Honor. Yes.
Miss Ambo, this is exactly the situation. So here's the documents y'all got. Your notice to vacate to her is dated March 6th. Even if I take it as true that you delivered it inside the front door, and there's certainly a question about that, the email to her right here that you gave her on March 11th says you have now until pay. So your notice to vacate, I don't think is valid. Because here you give her a new order that says, if you bring it in, we're going to proceed with eviction. We spoke and agreed to a missing payment on March 7th.
Your Honor, yes, we had a payment plan agreement, and
so that is true. So when Ms. Miller said there was a plan agreement, I didn't hear that from the plaintiff, but that's true.
Yes, Your Honor, that is true. That is true. Yes, ma'am.
And did she fulfill that agreement to pay in full?
No, ma'am.
Does she still currently, do both the defendants currently owe $6,500? Ms. Ambo?
Yes, ma'am.
Ms. Miller, is there any dispute that y'all owe $6,500 in back rent?
No, it is not, Your Honor, but I assure you, we are not trying to avoid payment. This has been a bit of an odd situation.
Trying to avoid payment, Ms. Miller.
No, of course.
The reality, though, is if your employer said to you, I don't have the money this week, can you just keep waiting? You would quit, right?
Correct.
Your landlord has not been paid in full since January.
Correct. My partner and I, the co-defendant and co-tenant, have.
And you are aware that they were trying to evict you. First on that email here that says y'all had a communication about you paying up on the 7th, and you did not pay up on the 7th, correct?
I was unable to at that time, correct.
So her reliance upon your promise, a second promise to pay on time, still did not go forward.
Well, that was the
Because
yes,
you promised
Your
in the
Honor.
contract
Yes.
to pay on the lease, and you didn't. And then you
Yes,
told her,
Your
I
Honor.
promise I'll pay by this date, and you didn't. And as we sit here
Yes,
today
Your
in
Honor.
court, still haven't paid her.
Correct, Your Honor.
Well, you want to win
Now,
because she didn't prove that she took a picture of the notice to vacate when she served it to you.
well, I would like to win based on a procedural issue. Yes. Had I not, though, I would be asking for a continuance. We have a house that is currently under
Can't give you a
escrow, and the
continuance. State
funds
law
are.
requires we have these hearings, right?
Of course, absolutely.
Your position is not one of correct legal argument. It's solely that she doesn't have a picture that proved to me that she got you the notice to vacate.
Yes, Your Honor. I understand that this is simply a procedural and that the greater issue still applies. I absolutely do.
Ms. Ambo,
Yes, Your Honor.
do you keep any better historical records of the work that you do as the assistant manager when you deliver those notices to vacate?
Yes, ma'am.
Do you have any of those documents?
All of the documentation I had submitted through Nationwide. Since the beginning of filing eviction, I initially filed eviction the first time in January. I hand delivered that notice to Miss Miller. And then we decided on the payment plan. It did not go through because there was no payment on March 7th. And that just became null and void.
Which one
Your
did
Honor.
you hand deliver to her?
I submitted, it was on January 6th, and I submitted that notice to vacate through Nationwide, and I hand delivered it to Miss Miller. That was
So
the first initial time.
The historical records show that they're giving notices out on the 6th, which would be the reason why on March 6th, another notice to vacate was delivered because they were delinquent.
Where can I see that, Ms. Carcos?
It should have been, I don't know if it was part of the file. If not, like the January 6th notice to vacate. Is that what you're asking for, Your Honor?
No, so I see a notice to vacate for March 6th, right? But Ms. Ambo testified just that there was a one before that from January.
Correct. There was one, I have it actually sitting in front of me from January 6th that they owed over $4,070.39.
What
And
happened with that notice to vacate?
Ms. Ambo, do you know why you guys didn't proceed on, is that when you guys moved into the payment plan?
Yes, ma'am. Yes, so that's correct. The first initial notice to vacate was on January 6th, and then that's when we motioned it to the payment plan agreement.
Ms. Miller, is that correct?
Yes, we had a hearing that was dismissed and canceled on the plaintiff's side that we entered into a payment plan.
Okay. And then y'all still didn't pay, so they gave you a new notice to vacate in March. And that's what
We had paid our
for this filing. Okay.
We had paid our first installment, and
Okay,
then we
then.
could not make our second installment in time. And I communicated that to them and was trying to work through it when she
All right.
went to file the eviction on March 12th.
Okay.
And Your Honor, just so it is reflected in the court, we are since in a position where we have absolutely every intention of paying in full, which I did communicate to Miss Ambo yesterday when she and I spoke as well.
Okay.
And do have those funds clearing in the next couple of weeks and plan on paying in full regardless of the outcome of the court.
All right, guys. Colloquially, y'all, because actually we're all, as I look at the cameras, it doesn't matter. Okay, thank y'all. That's a good information fact. And now I get a better sense of the whole thing and of truly knowledge bodies. All right, then. I do find the notice to vacate is proper. I find that based on the testimony, get all things together here, I do think that the March 6th was actually served. Albeit, Ms. Ambo, historic record, Ms. Carcos brought me some information there. I find that the monthly rent is $22.05, so it'd be a judgment for the plaintiff for $65.63. The appeal bond is twice the rent, it's $44.10. Miller, you don't have to come up with $44.10 if you can't afford it. And certainly, based on what I've heard today, it might be that you qualify for an affidavit of inability. There's a couple of things that parties can do. One thing, either party can appeal my decision. You have at least 5 days beginning tomorrow to do that. If you appeal and perfect it and pay the rent, then you can remain in the unit while the case is pending appeal with the higher court, right? And while that's doing, y'all can still try to work things out and get all caught up, and maybe it resolves itself. Over the next 5 days before the appeal deadline comes, certainly the parties can again negotiate. And if you come up with the money, it may be that they do not wish to. There's possibilities there. The landlord can notify me anytime in the next 5 days if they wish to set this aside. If y'all don't do anything, though, if no one appeals, if no one settles, if no one pulls this back, then on day 6, that's the day it would become a final and effective judgment, and that is the soonest that the landlord can have the writ of possession. Okay?
May I ask the court a question if you don't mind?
Absolutely. This is your chance to ask me questions. I'll see if I can answer them. Go ahead.
I appreciate that. I really do. Well, I do understand that per Ms. Embo, and I'm very sorry, our representative from Nationwide here, I don't remember your name. Their historical records being that they deliver notices to vacate on the 6th. Given the fact that I have a voicemail from the 7th from Ms. Ambo on my phone that I'm happy to play for the court, that procedurally she did not follow Texas Property Code 24.005 and deliver this inside the door. There is no evidence. We work and live at home, and we were home all day. And procedurally, this was not followed to a T. Our apartment, 700 square feet. She could not have knocked and entered the apartment without either of our knowledge. It would be a physical impossibility, unfortunately. I'm just asking the court to reconsider from a procedural standpoint. Again, this is never a situation that myself.
It was proper. That is definitely an issue you would take on appeal, Ms. Miller.
Understood, Your Honor. Thank you.
All right.
I appreciate it.
Any final questions, Ms. Carcos?
No, Your Honor, thank you.
Ms. Miller, any other questions? Certainly, we're going to send you the information. If we have a good email, you'll get all the stuff from us today about appeal. Reach out if you're interested in doing any of those things. Okay?
Understood, Your Honor. Thank you.
And definitely, y'all can still work it out. That's always a possibility.
Thank you, Your Honor.
All parties are excused. Good luck, everyone. Thank you.